Is a sick out the same as a strike? That's the question at the crux of the lawsuit against the West Ada Education Association. Hoping to prove that it is, and therefore illegal in Idaho, are a group of parents whose kids are in the West Ada School District and who didn't have class 2 days this week because more than 1,100 teachers called in sick both Monday and Tuesday. Well, their attorneys filed that lawsuit yesterday, right about the time the teachers union and the school district decided school will be back in session today, having agreed to work out some sort of resolution to the teachers' grievances. The teachers didn't want to work under the lax health standards because of COVID-19, and they believed they should be remote only while Ada County is under the red category. The district felt okay with going ahead with their alternating hybrid model, like schools were still in the yellow category. So about 650 teachers called in sick Monday and another 500 again on Tuesday to make a point that they wanted to see a change. This was announced late last week, giving parents little time to figure out alternatives for their kids who were supposed to be in school those days. Thus the lawsuit. They want this sick out deemed illegal and that they don't want to have it happen again. We spoke with the parents' attorneys today and asked, can calling in sick be considered a strike?
That's right. So for several decades now, since 1977, the law has been clear in Idaho that teacher strikes are illegal. And that makes sense, right? That's actually the case in 35 states. The teacher strikes are illegal. And that's because teachers, much like fire and police, are essential workers. We rely on them in our communities to make sure that things keep running. In this instance, the union is characterizing this as a work action, but the label isn't what's important. For my clients, these families, and for all the other families in West Ada, what's important is the kids didn't go to school, and parents had to call grandparents or neighbors and scramble to figure out childcare. And these kids weren't learning like they were supposed to be. And that's a strike. And we need a court to call it such.
At the time you filed this lawsuit, there had already been some sort of resolution. I mean, the teachers are back to work today. So does that make this lawsuit a moot point?
It doesn't. So we filed yesterday afternoon before we knew that they were going to go back today. But I think two things are really important. One, I wouldn't characterize this as having ended. I would characterize it as being on pause. Both the district and the union have said that they have not reached an agreement yet, that they are only back temporarily, and that the union has basically issued a demand that the district cave by its Tuesday board meeting, or we'll see another work action. And so we're asking a judge to hear and rule on this case as promptly as possible so that the school board, the union, and mostly the parents can have confidence at that point that regardless of what policy disagreements may exist, school's going to be on Wednesday.
And so therefore, this lawsuit is not a moot one because it's still up in the air.
Yeah, that's right. We are looking to the judge to provide us prompt relief. We need a court order this week in order to make sure that this doesn't happen anymore. And then more broadly to look to the future and say that this can't happen in this district or other districts in Idaho, that this just isn't a legitimate tool. Kids are not pawns, and they shouldn't be held hostage as a negotiating tactic between a union and a school board.
It's also worth pointing out the Idaho Freedom Foundation has had its hands in this lawsuit on the part of the parents. I did ask if the teachers could just claim they were in fact just sick, but as Mr. Sir pointed out, the union has been vocal in taking credit for organizing this sick out. And he's right. Neither party admitted to a resolution yesterday when it comes to the issues the teachers have had with working conditions. The district just asked for time to figure it out, and they got it until at least next week, Tuesday. Well, stated a few times in that 7-page complaint is the term common law. It's the basis of this lawsuit. Common law is a set of legal standards that go back centuries, older than Idaho, older than the United States, but still very much used in modern times. How does something so antiquated apply today? Well, we asked John Rummel, who's now a professor at the University of Idaho Law School. He's been there since 2011, but before that, he was an Idaho attorney where he focused mainly on employment and labor law litigation. And for 16 years, he was the general counsel for the Idaho Education Association, which is the statewide teachers union. While there, he represented members in rooms large and small, from local school board hearings to the United States Supreme Court. So he has some background in such issues. And we had some questions about Idaho law as it pertains to teachers. The first being, could you explain this common law thing?
Common law comes from the law of England, and that's the origins of our legal system. It's still in effect in the states today. But of course, today we have a lot more legislative law, statutes, and the like. So to the extent that the legislature has spoken on an issue and they've spoken in a way that's constitutional, then that can supersede common law.
And so basically, it is in this lawsuit because there is no law on the books as it pertains to teachers and whether or not they can strike. Is that correct?
Well, there's no statutory law. Teachers do have the benefit of a bargaining statute that was passed in the 1970s. Teachers and firefighters are specifically authorized by the legislature to bargain with their employers. But no, there really isn't any particular statutory provision regarding, sick outs or strikes or the like.
Is there precedent in Idaho that shows teacher strikes are illegal?
Well, there's language in the cases that the plaintiffs, the parents have cited, particularly the Oneida case. I think that case was decided in 1977, where the court basically says that, yes, generally speaking, teacher strikes under the common law were illegal. Now, that's a case that's, I think, now 43 years old, and it really hasn't been adjudicated in Idaho in any really meaningful way since that time. But that same case also said, even assuming it's illegal, even in the Oneida case, the court refused to issue an injunction because they found that the conduct of the school district in that case was inequitable. Perhaps the teachers might argue that they had a right to engage in this sick out because the school district was not looking after their concerns regarding a safe work environment.
Which is why Mr. Rummel said this lawsuit appears to be a three-sided dispute, that is, the parents, the teachers union, and the school district. And that's just one of the several issues that have to be considered by a judge in this case. The others being whether parents are the appropriate plaintiffs, since typically the parties in cases like these are the employer and the employee. Well, speaking of the employer, you heard him mention the school district and the work environment. Rummel tells us there's something called the clean hands doctrine, which is basically the court can deny equitable relief to someone who has violated good faith in respect to a claim. But the school district isn't named as a party here, and the parents just want to see the sick outs by teachers stop. We did ask the teachers union and the school district, the West Ada School District, about their take on this lawsuit, but we have not heard back as the start of the show. So we're going to see what happens before Tuesday next week, the scheduled West Ada School Board meeting.